In this video, we are going to be talking about failing to maintain lawful status, okay? Under 245C2 of the Immigration and Nationality Act, the law is very clear. It says that the person who is in unlawful immigrant status on the date of filing the application of adjustment of status and who has failed to continuously maintain a lawful status since entry in the United States is barred from adjusting status under Immigration and Nationality Act 245A. What is failing to maintain lawful status? And is there any exception? There is a tiny exception. If you claim that you failed to maintain status and it is not your fault, and it is a technical fault of USCIS or another agency that caused you to maintain to fail to maintain status, then you might apply the exception, right, and argue that you failed because it wasn't your fault or because of technical reasons, and that can be exempt. Basically, in other words, you might be able to adjust status, but we're going to really talk in detail about it, and hopefully we can help somebody adjust their status today. My name is Bijoux Ngwanda. I'm an immigration lawyer here based in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration cases. If you're new to my channel, again, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, you go ahead and please share, like, and don't forget to comment below. Also, you can join us on our private Facebook group where we answer questions live at least once a week or once every 2 weeks, basically twice a month, to be honest with you, because we're kind of busy. You know that we're handling really like complex immigration matters, and in the week to come we are going to be giving you testimonies of complex cases that we have been able to actually turn around. Okay, so we are going to talk about this exception here. Adjustment of status. In order to adjust status, you first of all have to have an approved petition. We already know that. And today we're going to focus on only two types of petitions. Family-based I-130 approved, employment-based I-140 approved. Okay? So when it comes to family-based, we're talking really about immediate relative, not people who are adult sons and daughters of U.S. citizens. Those people are not immediate relative for the purpose of adjusting status. That's why for them it takes forever, right? So in order to adjust status, the person must have been inspected and admitted, or parole in the United States. Parole, permission to enter, you can get it from the border. Some people get permission to enter from the border, and we know uncommon ways too to prove admission is way by wave through or by misrepresentation. People who come with documentation that they are not theirs and later on can prove it that they actually were inspected, provided that they can show those proof and ask for a waiver and hope that the waiver get granted. So those are uncommon way of showing admission, right? We've talked about that too before. Then the second criteria is be eligible to receive an immigrant visa. That's when we talk about inadmissibility issues. Then we have the third requirement, be admissible to the United States for permanent residence and have an immigrant visa immediately available at the time the application is filed. So adult sons and daughters, married or unmarried, of U.S. citizen or lawful permanent resident, siblings, this one does not apply to them because the visa is not immediately available by the time the application is filed. You have to wait for the visa to be current, right? Those are the people who, even when they're in the United States, they have trouble adjusting status, even when they have an approved petition, because they have to wait for the visa to become current, right? So now, if let's say somebody meets all those requirements, but unfortunately, when it comes to admissibility issue or inadmissibility issues, the person failed to maintain status. That's our focus today. I failed to maintain status. However, I'm claiming that the reason why I failed to maintain status is not my fault. It's for technical reasons. And how are you going to be able to demonstrate that, and what actually the regulation requires, right? The regulation only requires 4 criteria. If you fit into those 4 criteria, actually one of them, then you can actually say that I meet that exceptions. It's really a tiny exception, and the regulation only offers 4 reasons, to be honest, only 4 reasons that can actually serve as technical reasons or no fault of yours. The first one, let's start with the first one. The first one is the inaction of an individual or organization who is authorized by immigration regulation on and over whose actions the alien has no control. And in order for this exception to apply, the individual or the organization must acknowledge its inaction. Let me give you a specific example. Let's say you are a student, F1 student, and at some point you wanted to extend your visa or reinstate your visa, or something happened with your student visa, but you meet the requirement for extension or reinstatement. However, you were waiting for something from the school, and the school, within a specific period of time, failed to act to give you the necessary documents so that you can provide with USCIS. And because the school was inactive in that period of time, and that led you to fail to maintain status, you can claim it as an exception, as the technical reason, no fault of yours. However, for this exception to apply, the school has to acknowledge that it was their fault. They failed to act. Okay, that's a specific example. Then we have a second scenario. A second scenario says that a technical violation resulting from inaction by USCIS. That has to come from USCIS. Some people go with the fact that, well, at the time I applied for asylum, I was within status, and then not just I was within status, the entire application of asylum take longer than its processing time, and that had make me fail to maintain status. No fault of mine, the fault of USCIS. So I think I meet this exception, and it's subject to debate, right? So then we have really, for that second scenario, the regulation offers an example, a situation in which an applicant demonstrates that she filed a timely request to maintain status, and USCIS failed to act for technical reasons. That goes with reinstatement of visa, basically changing of status, stuff like that. USCIS failed to maintain, or USCIS failed to process your application within the time that they're supposed to process it, and probably they process it late and you fail to maintain status. Then we have the third scenario where the technical violation resulting from the physical inability of an applicant to request an extension of stay. Physically, you're sick and you're at hospital. So basically, technically, you cannot apply to extend your visa, and that's why you failed to maintain your status, legal status, because of your physical inability. And if you have proof of it, you can show and meet that exception, okay? And the fourth scenario is basically a technical violation resulting from USCIS application for the maximum 5 or 6 year period of stay for certain H1 nurses, only if the applicant was subsequently reinstated to H1 status in accordance with the terms of Public Law 101-656. This is very specific to nurses under H1 status, and they were supposed to be reinstated, but because of USCIS, the reinstatement came late. They failed to maintain status in between, and now they are faced with failure to continuously maintaining status. They cannot adjust. But again, if it was because of USCIS, the reinstatement of their visa came late, they can show that they meet that exception. Again, this exception is very tiny. It's so open to debate. In certain circuits, even someone has argued before that it's because of the lawyer that I failed to maintain status, because I was given how they call it, not sufficient counsel, so basically ineffective counsel. That's why I failed to maintain status. Some court can debate that and pretty much go with that explanation as an argument, and some court will not, okay, because then they can argue too that you could have gone to different people with different profession expertise, so it's open to debate, okay? So having said that, this is very complex matter, okay? You cannot, to be honest, figure this one on your own. Consult with a qualifying lawyer. Call my office, 202-751-2180. Click the link in the description box so we can really see if we can basically claim that you failed to maintain status because it wasn't your fault, and get you to adjust status if that's just the one requirement you failed to meet under adjustment of status, okay? So this is it for today. Until next time, bye-bye.